Let's go back to your jury instructions, page 13, please. All right, on page 13, submitting case to the jury. In just a few moments, you'll be taken to the jury room by the bailiff. The first thing you should do is choose a foreperson who will preside over your deliberations. The foreperson should see to it that your discussions are carried on in an organized way and that everyone has a fair chance to be heard. It is also the foreperson's job to sign and date the verdict form when all of you have agreed on a verdict and to bring the verdict form back to the courtroom when you return. During deliberations, jurors must communicate about the case only with one another and only when all jurors are present in the jury room. You are not to communicate with any person outside the jury about this case. Until you have reached a verdict, you must not talk about this case in person or through the telephone, writing, or electronic communication such as a blog, Twitter, email, text message, or any other means. Do not contact anyone to assist you during deliberations. These communication rules apply until I discharge you at the end of the case. If you become aware of any violation of these instructions or any other instruction I've given in this case, you must tell me by giving a note to the bailiff. Many of you may have cell phones, tablets, laptops, or other electronic devices here in the courtroom. The rules do not allow you to bring your phones or any of those types of electronic devices into the jury room during deliberations. Kindly leave those devices with the bailiff while you deliberate. If you need to communicate with me, send a note through the bailiff. If you have voted, do not disclose the actual vote in the note. If you have a question, I will talk with the attorneys before I answer, so it may take some time. You may continue your deliberations while you wait for my answer. I will answer any questions if I can in writing or orally here in open court. During the trial, items were received into evidence as exhibits. You may examine whatever exhibits you think will help you in your deliberations. The exhibits will be delivered to you shortly. In closing, let me remind you that it is important that you follow the law spelled out in these instructions in deciding your verdict. There are no other laws that apply to this case. Even if you do not like the laws that must be applied, you must use them. For more than 2 centuries, we have lived by the Constitution and the law. No juror has the right to violate rules we all share. Great. Let me talk just a little bit about what, as a practical matter, what's going to happen. We're going to begin deliberations. It's going to take a little bit for us to go through the evidence, make sure we're sending back to you what was placed in evidence, so be patient with us a little bit for that. You will take breaks periodically during your deliberations. In other words, there's, every hour or so you may take a break, but all deliberations have to be joint deliberations. You can't have any situation where some small group is deliberating, so if there's a break, everybody has to stop till everybody's back. We will feed you this evening. If we have not reached a verdict by about 8 or 9 o'clock, then we're going to take you to a hotel. You can report to your family and those people that are concerned about you, your schedule, but please don't discuss the case with them, and please don't advise them where we're housing you. We don't need that to be public information. So anyway, let's go sidebar for a minute.
Put your instructions up and we need another copy. This your old instructions? Do you have, did you get yours?
I had put you
Hey, come on now, don't get me in trouble. Where's yours?
Professor Barton, you need to remain here with us. Rest of you may step out, begin your deliberations. Take your notes with you, take your jury instructions, your verdict form. Even if you didn't make any notes, you want to take a pad, you may want something to write on during your deliberations. We'll be sending the evidence to you. The attorneys can be going through the evidence. What? And you have a number for him, because if we have another phase, we'll need it.
Yeah.
Everybody be seated, please, or step out of the courtroom. The attorneys can be going through the evidence. Well, we have alternates in this case. We started with 2, we ended up with 1. You're our alternate. I hope you don't feel like we're wasting your time. An awful lot goes into getting one of these cases going, and we didn't want to have to start all over again because we lost another juror. If we hadn't had alternates, frankly, we would have been done when Miss Fondo got sick. So anyway, those things do happen. We do appreciate your time and attention. We still have a potential for needing you further. If there is a first-degree murder verdict as to Mr. Garcia, there will be a penalty phase proceeding. I'm going to talk with the attorneys as to exactly when that will start. It won't be this week. It'll be either next Monday or Tuesday. I'm going to talk with them about the exact scheduling of that. That will probably take 2 days. If that occurs, we will need you back for that. Because of that, I would ask that you do 2 things for me. I would ask that you not discuss the case with anyone. You may get solicited by media people wanting to know what your thoughts are. I would ask that you decline to discuss the facts with anyone until we've resolved the case. If it is resolved without needing to have another phase of the proceeding, then you're free to talk about it or not as you see fit. We'll advise you what happens, and we'll be in contact with you. Barbara says she has a good number for you. Is that correct, Madam Clerk? Yes. We'll call you and let you know what's going on. It may be a couple days before we know what's going on, so don't be worried that you haven't heard from us. So in the meantime, don't discuss the case with anyone. Do you have any questions about what's expected of you? The clerk asked me to give you this note. I guess this is just an attendance letter. I don't know whether you need that or not. But, we appreciate you being with us. Deputy Granger, you're going to get him with court administration and get him safely on his way. Thank you, sir. Have the attorneys had an opportunity to go through the evidence? So we're still doing it? There might be things. Why don't I go burn a copy of that? Is that the evidence list? Oh, why don't I go burn a couple copies of that so everybody can have it? And I'll come back in about 15 minutes.
That's the one for the jury.
Right, that's what I wanted to see. I'll make a copy. I'll be back in about 15 minutes. I want to confirm on the record. Be seated, please, sir.
Okay.
Does everybody have a chance to go through the evidence and confirm what's being sent to the jury room as what was properly placed in evidence?
Judge, yeah, for Mr. Garcia, we did, and it is consistent with what was admitted.
Save for Ms. McMadeleine.
Okay.
Same for the state judge.
Okay, so no issues on any of that. Any issues on the list, the clerks including with it?
Not from Mr. Garcia.
Not from Ms. Mike Brown. And Your Honor, of course, with the CDs, it's, we take them at face value.
Right.
But labeled correctly, everything is fine.
Yeah, I don't think was anything particular controversial in the list, anything. All right, so that can be delivered. McBannon was not involved in this discussion, so y'all are free to go if you wish. Talk about a schedule for next week, just in case we, if we get a first-degree murder verdict as to Mr. Garcia, need to discuss how we want to proceed. We do have a juror, Ms. Evans, who has an ultrasound scheduled for Monday at 11, who is very much wants to be able to do that. I guess she's pregnant, and this is the ultrasound to see how things are going. But I just mentioned that is to put in the mix on how we want to proceed. The state have a position and how you'd like to proceed.
No, sir, I'm available whenever the court wishes.
Just hanging it.
Obviously, I understand this is Evan's situation. As the court knows, me and Mr. Padilla have been, living in
Right.
Leon County for the past almost month. I'll leave it up to the court, but I'd like to start on Monday. I mean, if they come back with a verdict, I want to strike while the iron's hot and get things done.
What if we started at 1 o'clock on Monday? How would that work for you?
That's fine with me. I mean, I think that our presentation is, we're going to be presenting more witnesses from an expert position. So.
How much the state have?
I'll say 3 witnesses, Judge.
How long witnesses do you think you're talking about?
Say 3 hours, so.
So we probably could get the evidence done Monday afternoon. You're a witness, an expert witness, so they usually take longer. So how long are you thinking she'll take? Oh, it's not going to be lengthy. So it would be doable to get the evidence done Monday afternoon, and then we could figure out the jury instructions Monday evening and present it to the jury on Tuesday morning. I mean, nothing ever goes exactly by plan, but that'd be kind of a working hypothesis of how we proceed.
That'll be fine, Judge.
That works for y'all. It would facilitate jury instructions if we knew what you were wanting to say in terms of mitigating circumstances. Have you discussed how you want to do that? I mean, some ask for statutory and then the catch-all. Some want a list of different things. That is the only part that gets a little confusing.
Can I get your answer before 5 o'clock tomorrow?
Yeah. I tell you, it'd be more helpful if you could get one before, say, 1 o'clock tomorrow, so I had the afternoon to work on it. So
That's fine.
I hope to not work on it all weekend, but I have drafted some with just a blank space for mitigating circumstances. I've included what the state listed as aggravating factors in their notice. If y'all want us to, we can send those to you for your initial perusal.
Please.
All right. Who do you want us to send those to, Ms. Kappelman?
Me.
Okay. All right. All right. Anything else we need to discuss?
No.
One thing from the state, Judge, I did mark as 197 a court exhibit, which is a just containing the PowerPoint that I presented in closing. Your Honor wants to accept that item?
You want to make part of the record?
I'm told that I have to.
What's that?
Yes, that's what I'm asking.
I don't know. Is the defense seeking that? There were no objections to it. I'm not sure why we would do so.
Just to make it part of the court record, Judge?
Right.
That's fine.
I believe that's correct.
You want that done?
I believe it should be. Yeah.
What's that?
I believe, yeah, it should be part of the record.
Okay, we'll make it part of the record then. Court exhibit. All right, anything else?
Other than the state.
All right, and you're prepared to deliver the evidence
Yes.
to the jury? You may do so, Madam Clerk, and we do have a court administration person present that if they need technical assistance, that will provide them technical assistance. All right? We'll be in recess till we hear further from the jury.
Your Honor, will your JA notify Kathy of your plans for this? Like the days and the time and everything?
We can.
Okay, thanks.
Okay. This was just a spare copy.
Okay.
Was that part of the file?
Yes, sir, I took it out.
Oh, okay.
The initial that I
Okay. But everybody got copies?
Yes, sir. Yes, sir. Yeah, I'll check it in and say about an hour.